Hey, everybody. Good evening to you all. We have a little bit of a different setup. We're trying out kind of a home away from home kind of studio kind of thing. So bear with it. We're trying to get things right. And it's important we get things right. All right. So we're also doing something a little different tonight as well as far as the subject of our reading. We're going to be reading a law journal article called Inevitable Discovery and Exception Beyond the Fruits by Mr. Robert M. Bloom, published in the American Journal of Criminal Law, 79th volume, 1992-1993 edition. All right. Introduction. The major remedy in the United States for addressing a police illegality is the suppression of the evidence found as a result of that illegality. This is the so-called exclusionary rule. The remedy was thought to be necessary because Justice Clark explained in Mapp v. Ohio, other remedies, civil monetary relief, or criminal prosecution of the offending officer have not been effective. If the police officer knows that evidence illegally obtained cannot be used at a later trial, he will be deterred from violating any individual's rights. Although in Mapp other reasons for the exclusionary rule were suggested, such as the imperative of social judicial integrity, deterrence has become the sole justification relied upon by the present court for the exclusionary rule. In Silverthorne Lumber Company versus United States, the Supreme Court reasoned that to give meaning to the exclusionary rule, it was necessary to apply the exclusion sanction not only to the direct result of the illegality, but also to the indirect consequences of the illegality as well. Quote, the essence of a provision forbidding the acquisition of evidence in a certain way is not that it merely the evidence so acquired shall not be used before this court, but that it shall not be used at all. The concept later became known as the fruit of the poisonous tree doctrine. Right? So, in this article, this author, Mr. Bloom, is going to refer to the direct or intermediate result of an illegality as a primary evidence to the indirect result or the fruits of the illegality as secondary evidence. So if it's fruit of the poisonous tree, that's going to be called secondary illegality or secondary evidence, and the primary will be the direct illegality that an officer does when they violate your Fourth Amendment rights. The wisdom of the exclusionary remedy has been questioned by the Supreme Court since the 1970s. Consequently, that's cool. The court has chipped away at the applicability of the exclusionary rule, particularly with regards to the exclusion of secondary evidence, or so-called harvest of the fruits of the poisonous tree. The court has created new exceptions and expanded on existing exceptions with the exclusion of the secondary evidence. This concern for a limitation on the exclusionary rule with regard to secondary evidence was first expressed in Silverthorne, when the court, on the one hand, created a derivative evidence exclusion standard and at the same time modified its effect by saying, quote, of course, this does not mean that the facts thus obtained illegally become sacred and inaccessible, end quote. Based on this rationale, the court created an exception to secondary evidence exclusion through the so-called independent source exception. This exception arguably is not really an exception to the fruits doctrine because it allows for the introduction of evidence obtained not by the illegality, but by a separate and distinct method, an independent source. In the independent source situation, it can be said that the fruit not only grows from the poisonous tree, but also grows from another non-poisonous tree. Another exception to the fruit of the poisonous tree doctrine created by the Supreme Court is the attenuation of the taint exception. This exception is analogous to the tort doctrine of proximate cause. The rationale for this exception is that the secondary evidence, even though it can be traced back to the initial illegality, is too distant or attenuated from the illegality to be excluded. In other words, much has occurred between the illegality and the finding of the secondary evidence. Quote, we need not hold that all evidence is fruit of the poisonous tree, simply because it would not have come to light but for the illegal actions of the police. Rather, the more apt question in such cases is whether granting establishment of the primary illegality, the evidence to which instant objection is made, has been come at by an exploitation of that illegality or instead by a means sufficiently distinguishable to be purged of the primary taint of the illegality. The final and most recent exception created by the Supreme Court is the inevitable discovery exception. This exception is closely aligned with closely aligned analytically with the independent source doctrine in that it allows the government to avoid the fruits doctrine if it can show that an independent or alternate investigation would have led to the evidence in question. However, unlike the independent source doctrine, in which the alternative source actually leads to the evidence in question, the inevitable discovery doctrine or exception is speculative, since the independent investigation only hypothetically, not actually, leads to the evidence. It is this inevitable discovery exception that this article explores. It takes a close look at Nix v. Williams, the Supreme Court decision that recognized the inevitable discovery exception, analyzes its various components, and briefly looks at how these components have been applied by subsequent courts. Robert M. Bloom, not Lewis Bloom. Robert M. Bloom. It's in the description. He's the author of this. Okay. The article then separately explores two areas which are not directly related and discussed in Nix: the utilization of the inevitable discovery exception to avoid exclusion of primary evidence, and its utilization to avoid the warrant requirement of the Fourth Amendment. This article will demonstrate that in these two areas, the lower courts have expanded the inevitable discovery exception beyond what was originally envisioned by the Supreme Court in Nix, and that this expansion has seriously affected the vitality of the exclusionary rule as well as the Fourth Amendment warrant requirement. This article will further demonstrate that the significant expansion has not received the concern or analysis that it deserves. 2. The Nix decision. The inevitable discovery exception had its genesis in Summer versus United States. In Summer, the police entered the defendant's premises unlawfully and were informed by the defendant's wife that he was out, but that he would be delivering the stuff and returning to the apartment shortly. After conducting a search of the apartment, the officers went outside and waited for the defendant's arrival. Within a short period of time, the defendant drove up, and the police observed the stuff, alcohol, and sugar in the car. Summer admitted to the possession of alcohol and he was arrested. The alcohol and sugar was seized. The defendant filed a motion to suppress the physical evidence, which the lower court granted. However, the Second Circuit remanded to the lower court to retry the issue of evidence admissibility, stating that the inquiry may show that quite independently from the information unlawfully obtained from the defendant's wife, the officers would have gone to the street, have waited for Summer, and have arrested him exactly as they did. If it appears that they did not need the information, the seizure may have been lawful. The Circuit Court did not define this holding as inevitable discovery, nor did it address it in terms of the exceptions to the fruits doctrine. The inevitable discovery exception was first adopted by the Supreme Court in Nix v. Williams, which involved the horrendous crime of kidnapping and murder of a 10-year-old girl on Christmas Eve. The police illegality in this case was a violation of the Sixth Amendment, and the statement was obtained by a direct result of that violation. This statement was the primary evidence which led police to the body of the victim, the secondary evidence. Despite the clear causation between the constitutional violation and the secondary evidence, the court held that the evidence for the body would be introduced because the body would inevitably have been discovered. The facts, here's a footnote here too. So 21, right? Footnote 21. The police, by use of a psychological ploy, which was a Christian burial speech, obtained a statement from the defendant in Nix after his right to counsel had attached. Since counsel had attached to this deliberate elicitation of the statement, it constituted a violation of the Sixth Amendment, see Masai versus United States. The court pointed out that the fruits doctrine was applicable to Fourth and Fifth Amendment as well. Thus, the inevitable discovery exception law applies beyond merely the Sixth Amendment. Footnote 22 says, all of the facts in Nix indicate the inevitable discovery exception was used to avoid the exclusion of the body, i.e. physical evidence. The factor was relied upon by the Alaska Court of Appeals when it refused to apply the inevitable discovery exception to a statement as opposed to physical evidence in Unger versus Sinto. All right, the decision in Nix was based on a factual determination by the lower court that a search party operating in the area would have found the body had the search not been suspended. Thus, the court adopted the inevitable discovery exception to the fruits doctrine. The court, in adopting the inevitable discovery doctrine, compared it to the independent source doctrine. Justice Brennan, in his dissent, took exception with the comparison to the independent source exception. He pointed out that the independent source exception allows the prosecution to use evidence that was in fact obtained by lawful means, whereas the inevitable discovery doctrine deals with evidence which was discovered as a result of an illegality. The Nix court, in determining the scope of the exclusionary rule for secondary evidence, reasoned that the police should be put, quote, in the same, not a worse position that they would have been in if no police error or misconduct had occurred. In other words, if the police can establish that they would have found the evidence regardless of the illegality, they should not be put in a worse position simply because the illegality had, in fact, taken place. It should be emphasized that the court was directing this comment to the derivative quality of the evidence and limited its comment to that. It is interesting to note that the court took a restorative approach to the exclusionary rule. That is, police should not be put in a worse position as a result of their illegality. To justify this approach, the court pointed out that the inevitable discovery cases, the deterrence rationale of the exclusionary rule would not have served because the evidence wouldn't have been found anyway. However, this approach does not adequately address the wrong that has occurred. It also deviates from the traditional understanding of the exclusionary rule, where the state is put in a worse position by the loss of valuable evidence whenever the exclusionary rule applies. The rule is primarily designed to prevent future wrongs, not to evaluate the present ramifications of the wrongs the police committed. In Nix, the Supreme Court establishes a preponderance of evidence as the burden for proof that the state may meet to establish the inevitable discovery exception. A vast majority of jurisdictions follow this evidentiary standard. An objective of the various burdens was to aid the courts in their efforts to make certain that the evidence would indeed be found in the absence of unlawful police activity. For this reason, Justice Brennan, in his dissent in Nix, argued for requiring a higher standard of proof by the prosecution due to the speculative aspect of inevitable discovery exception. He argued for a clear and convincing evidence standard as opposed to the preponderance of the evidence standard adopted by the majority. To counterdeck Justice Brennan's argument, the majority sought to reduce the speculative aspect of the exception by requiring that the alternative investigation must have at least been started for the exception to apply. They stated that the inevitable discovery exception, quote, involves no speculative elements but focuses on demonstrated historical facts, end quote. This approach was consistent with the facts of Nix, in which police were in the process of scouring the roadside when the body was found. The article explores the aspect in greater detail, and when it looks at the effect of the inevitable discovery exception on warrant requirements. Prior to Nix, the Supreme Court had recognized the importance of good faith when considering the exceptions to the Fruits Doctrine. In Brown v. Illinois, the court, in determining the thrust of the Fruits Doctrine, stated that, quote, the purpose and flagrancy of the official misconduct is rather particularly relevant. Later on, the Supreme Court in United States v. Soccolicini, analyzed that an attenuation of the taint doctrine as it applied to the finding of live witnesses. The court indicated that, quote, considerations relating to the exclusionary rule and the constitutional principles which it is designed to protect must play a part in the attenuation analysis. It further indicated that the flagrancy of the illegality was an important factor in determining whether the application of the exclusionary rule would have a deterrent effect. Nix was a departure from these good faith concerns. In Nix, the notion of good faith requirement was rejected by the court, as it did not require the state to show the absence of bad faith. The court went through a balancing test, weighing the cost of imposing a good faith requirement on the state with whatever deterrence benefits might result. It concluded that to require the state to show the absence of any bad faith would impose a huge societal cost because it would deprive juries of truthful facts as well as put the police in a worse position. The court found that the use of inevitable discovery exception would have a limited deterrent effect because a police officer, quote, would rarely, if ever, be in a position to calculate whether the evidence sought would inevitably be discovered, end quote. He would therefore avoid any questionable practices which might result in the suppression of the evidence as well as departmental sanctions and civil liability. However, the court seems short-sighted in this conclusion, especially with no regard to avoiding the warrant requirement. On to Section 3, so 1 second. Wet the old whistle, fill the old lungs. All right. Most of the circuits have utilized the inevitable discovery exception to allow the introduction of primary evidence, and this has usually been done without any discussion. United States versus Mancera-Lando, and facts similar to United States currency. presents a good example of a circuit utilizing the inevitable discovery exception to avoid exclusion of primary evidence. The case involved an illegal search of an automobile in which primary evidence was found. Due to an inventory procedure which would have uncovered the evidence, exclusion was avoided by the use of the inevitable discovery exception. 49. Oh yeah. What happened here? Oh, it doesn't have the facts. Oh well. The court did not discuss the appropriateness of the use of inevitable discovery for primary evidence. It just automatically applied it. Following the lead of the circuit, states have started to apply the inevitable discovery exception to primary as well as secondary evidence, and generally, this has also been done without any discussion. In New Jersey, the court explicitly allowed application of the inevitable discovery rule to primary evidence, but it created a more stringent standard, quote, restrictive formulation of the inevitable discovery exception. This formulation imposes a clear and convincing burden of proof on the prosecution, a higher standard than the preponderance of evidence standard adopted by the Supreme Court in Nix. The expansion to primary evidence of the inevitable discovery exception occurring in the circuit courts and the state courts potentially has great ramifications on the continued vitality of the exclusionary rule. To analyze this trend properly, it is useful to have an understanding of the Supreme Court's approach to the exclusionary rule. So, over time, the court, in continuing to apply the exclusionary rule to address police illegality, has concluded that its only benefit is to deter police misconduct. Quote, the rule is calculated to prevent, not repair. Its purpose is deter, to compel respect for constitutional guarantee in the only effective available way by removing the incentive to disregard it, end quote. Through a balancing test, which is utilized to determine whether to apply the exclusionary rule in a particular context, the court has implemented its deterrence rationale. The test balances the benefits of deterrence with the social cost of suppressing reliable evidence. When the cost of exclusion outweigh the benefits of deterrence, the exclusionary rule is not applied. In applying this balancing test, the court has been especially cognizant of the deterrence benefit resulting from excluding primary evidence at a criminal trial from the prosecution case in chief, and it has been reluctant to create exceptions to the exclusionary rule in that context. For example, in Stone v. Powell, the court specifically indicated the deterrent rationale had its greatest benefit for the suppression of evidence at the trial stage. Even at United States versus Leon, where the court created a good faith exception to the exclusionary rule for the exclusion of evidence in the prosecution of the case in chief, the court took a narrow view as to what would amount to a good faith exception. The court limited the good faith exception to those instances where the officer conducts a search pursuant to a warrant. Quote, the deterrent purpose of the exclusionary rule necessarily assumes that the police have engaged in willfully or at the very least negligent conduct which has deprived the defendant of some right. By refusing to admit evidence gained as a result of such conduct, the courts hope to instill in those particular investigating officers or their future counterparts a great degree of care towards the rights of the accused. Where the official action was pursued in complete good faith, however, deterrence rationale loses much of its force. In short, where the officer's conduct is objectively reasonable, excluding the evidence will not further the ends of the exclusionary rule in any appreciable way. For it is painfully apparent that the officer is acting as a reasonable officer would and should act in similar circumstances. Excluding the evidence can in no way affect his future conduct unless it is to make him less willing to do his job. The court, in creating this narrow exception, continued to recognize the vitality of the exclusionary rule by pointing out that, quote, the court has, to be sure, not seriously questioned, in the absence of a more efficacious sanction, the continued application of the rule to suppress evidence from the prosecution's case where a Fourth Amendment violation has been substantial and deliberate. The court, in creating this narrow exception, the court has recognized in its employment of the exclusionary rule the distinction between primary and secondary evidence. The concern for limiting the exceptions to the exclusionary doctrine during the prosecution's case, especially regarding primary evidence, has permeated the court's analysis of the exceptions to the Fruits doctrine. In applying the attenuation of taint exception, the court has examined how closely the secondary evidence is tied to the primary evidence in order to determine the benefits from the use of the exclusionary rule. The point at which the taint becomes attenuated has been viewed as, quote, the point of diminishing returns of the deterrence principle, at which point the detrimental consequences of illegal police action will no longer justify the cost of the exclusion. The proposition was also emphasized in Wong Sun versus United States, where they said, quote, the exclusionary rule has traditionally barred us from trial all tangible materials obtained during or as a result of a lawful invasion. Yep. The exclusionary rule, the court, has indicated that one would have to analyze each factual situation and determine how closely tied and contested the evidence was to the illegality. Where there is a close causal connection between the illegality and the secondary evidence, the exclusionary remedy would be most efficacious. However, if the causal connection is sufficiently attenuated, an exception to the exclusionary rule would be appropriate. Thus, in both the application of the fruits doctrine as well as the creation of exceptions to the exclusionary rule, the court has shown sensitivity and indeed reluctance to limit the exclusionary remedy for primary evidence. The Nix decision, which established the inevitable discovery exception, and to date remains the only Supreme Court case which deals directly with this exception, presents a strong argument for limiting this exception to secondary evidence, as it involves facts that dealt with the exclusion of secondary evidence. Within its analysis, the court referred to suppression of tainted fruit, and the case cited in this context involves the exceptions to the fruits doctrine. Further, the court, in its discussion of the exclusionary rule, once again referred exclusively to the secondary evidence. Thus, based upon the facts as well as the rationale of Nix, the court's attention understandably has focused exclusively on secondary evidence. There was no discussion of the effects of this exception on primary evidence. At least one circuit court has subsequently utilized the Nix decision to limit explicitly the inevitable discovery doctrine to secondary evidence. In U.S. versus $639,580 in U.S. currency, which are facts similar to Mancera-Londano, the government sought to use an inevitable inventory search to justify warrantless discovery of primary evidence. The case involved a warrantless search of luggage, which resulted in the finding of evidence. Since there was an existing inventory procedure, the government argued that the evidence in the luggage would have been found anyways. The D.C. Circuit rejected this argument, saying that the Nix decision was limited to derivative evidence. Quote, "Whatever one may think of the distinction between primary and secondary evidence, the fact remains that Nix drew it, and did so for the purpose of demonstrating that the deterrent effects of the exclusionary rule would not be lessened. The D.C. Circuit admitted, however, that many circuits have, quote, either rejected or ignored any distinction between primary and derivative evidence, as well as the deterrence inquiry called for by Nix. In some states, the distinction between primary and secondary evidence has been explicitly recognized by the courts for some time. As early as in State v. Croson, inevitable discovery has been applied only to the purge the taint of secondary but never primary evidence. Subsequent to Nix, some of the state courts, through the use of their own laws, have even been more vigilant, limiting the use of inevitable discovery exclusively to secondary evidence. In New York, the courts have interpreted the state constitutional provisions as to ensure that the use of the inevitable discovery exception is limited to secondary evidence. In Oregon, appeals courts have turned to the state statute that codified the fruits of the poisonous tree doctrine and interpreted the language of the statute, which reads, quote, "As a result of an unlawful search or seizure, other evidence is discovered subsequently," to mean that the inevitable discovery exception applies only to secondary as opposed to primary evidence. The Texas Court of Appeals, although it does not explicitly discuss the use of the inevitable discovery exception for primary evidence, implicitly indicates that its application is limited to secondary evidence, because the court classifies the inevitable discovery as an exception to the fruits of the poisonous tree doctrine. On the other side of the ledger, Murphy versus United States, an independent source decision, has provided support for excluding primary evidence via the inevitable discovery exception. This is not surprising given the previous discussed close relationship between the independent source exception and the inevitable discovery exception. The Murray case has been cited for the proposition that there is no distinction to be drawn between primary and secondary evidence with regard to the deterrent effect of the exclusionary rule on illegalities of law enforcement. In Murray, federal agents performed an illegal warrantless search which resulted in the discovery of bales of marijuana, as it was the direct result of the illegality. The federal agents left the bales untouched and then went to warrant based upon previously obtained evidence which was separate and distinct from the discovery of the marijuana. The same agents then executed the warrant some 8 hours later after their initial illegal entry and seized the previously discovered marijuana. The majority of the court, in the decision by Justice Scalia, allowed for the introduction of the bales despite the illegal initial search, provided the lawful entry with the warrant was based upon the information not related to the initial entry. The majority refused to distinguish between primary and secondary evidence. This reasoning, coupled with the previously mentioned close relationship between the inevitable discovery doctrine and the independent source doctrine, has invited lower courts to utilize the Murray decision to support their use of inevitable discovery exceptions to avoid the exclusion of primary evidence. As indicated, support can be found for either applying the inevitable discovery to primary evidence or limiting its use exclusively to secondary evidence. On one hand, the court's sensitivity to limiting exceptions to the exclusionary rule during the prosecution's case in chief, as expressed throughout Leon. Its efforts to limit the exceptions to the fruits doctrine when secondary evidence is closely tied to the primary evidence, and when the benefits of deterrence when dealing with the direct result of the illegality argue persuasively for limiting the inevitable discovery exception to secondary evidence. In addition, the Nix decision was specifically limited by its facts and analysis to only secondary evidence. On the other hand, the Murray decision, recognizing the close relationship between the independent source rule and the inevitable discovery exception, provides support for the expansion of the inevitable discovery exception to primary evidence. Quote, "It is possible to read petitioner's brief as asserting the more narrow position that the independent source doctrine does apply to independent acquisition of evidence previously derived indirectly from an unlawful search, but does not apply to what they call primary evidence, that is, evidence acquired during the course of the illegal search itself. In addition to finding no support in our precedent, citing Silverthorne, the strange distinction would produce results bearing no relation to the policies of the exclusionary rule. It would mean, for example, that the government's knowledge of the existence and condition of a dead body, knowledge lawfully acquired through an independent source, would have to be excluded if a government agent had previously observed the body during an unlawful search of the defendant's apartment, but not if it had observed a notation that the body was buried in a certain location, producing consequential discovery of the corpse. Given the ramifications that the use of the inevitable discovery exception has on the exclusionary rule, it seems that courts should at least recognize that they are using it to exclude primary evidence and discuss the expansion rather than applying it automatically. It further should be recognized that this expansion is beyond Nix, the only Supreme Court case dealing directly with the inevitable discovery exception." There's part 4, part 3. We're on to part 4. Miles to go before we sleep. Miles to go before we sleep. This is actually the shortest of the articles, of the law review articles. So I figure we start with that one. It's the shortest. It's a little baby one. All right. Part 4, warrant requirement. Overview. The Supreme Court has indicated that the Fourth Amendment warrant requirement provides a useful buffer between police officer and the individual. Quote, "The point of the Fourth Amendment, which is not often grasped by zealous officers, is not that it denies law enforcement the support of usual inferences which reasonably men draw from evidence. Its protection consists in requiring that those inferences be drawn by a neutral and detached magistrate instead of being judged by the officer engaged in the often competitive enterprise of ferreting out crimes. Given this important objective, the court has at times limited the opportunities for warrantless police activity. Quote, "It is a cardinal principle that warrantless searches are per se unreasonable unless the search falls within a few specifically established and well-delineated exceptions." Nevertheless, that's from Mincy versus Arizona. That quote is. Nevertheless, the court has pointed out by Justice Scalia the court has lurched back and forth between imposing categorical warrant requirements and looking for reasonableness alone. He further points out that, quote, "the warrant requirement has become so riddled with exceptions that it is basically unrecognizable." The deeds of the Supreme Court would support Scalia's observation, as the court has been liberal in its expansion of the exceptions to the warrant requirements of the Fourth Amendment. By extending the existing exceptions to the warrant requirement, the court has expanded on the opportunities for warrantless police activity. For example, in Florida v. Yimino, the court expanded the scope of a consent search, one of the traditional ways of avoiding warrants, and in California v. Acevedo, they expanded an automobile exception to the warrant requirement by allowing for a search of containers. As this article will demonstrate, the utilization of an inevitable discovery exception further limits the use of already limited warrant requirements. Inevitable discovery. B. The Nix court, in discounting the negative effect that the inevitable discovery exception would have on the deterrence rationale of the exclusionary rule, stated in reference to the police that, quote, "there would be little to gain from taking any dubious shortcuts to obtain the evidence," close quote. The court naively felt that a police officer who was about to obtain evidence in an illegal manner would not be able to calculate whether that evidence would have been inevitably discovered. But the Nix decision dealt with a Sixth Amendment violation. The court probably was not focusing on what the effect of this exception would have on Fourth Amendment warrant requirements. To the extent that the Nix court concluded that there would be a limited deterrence effect by utilizing the inevitable discovery exception, its reasoning was flawed with regard to the warrant requirement. The exclusionary rule provides an incentive for police to follow the law. When exceptions to the exclusionary rule are created, the result is to remove this incentive. The exceptions created thus far by way of balancing previously mentioned have, at least arguably, done little to remove the incentive to follow the law. For example, the court pointed out in Leon that if the police did everything they thought they needed to do, no incentives would be removed because in hindsight they would not have done things in the same way. However, the existence of the inevitable discovery exception will provide police with an incentive to avoid the warrant requirement. The police might seek the most expeditious method of obtaining the evidence without regard to its illegality, knowing that as long as they could have obtained the evidence legally, their efforts would not result in its suppression. This approach will indeed affect the deterrence rationale of the exclusionary rule, as it will encourage the police to take procedural shortcuts rather than to comply with the law. For example, if the police can determine that they could have gotten a search warrant, what incentive will be for them to go actively get one by jumping through the procedural hurdle of obtaining one, since the effects of an illegal warrantless search could be nullified by the application of the inevitable discovery doctrine? United States currency is illustrative of this point. The case involved an illegal warrantless search of luggage in which the government sought to avoid the scope of the exclusionary rule by arguing the, quote, cash, keys, and ledgers would have been discovered through an existing inventory procedure. The court, in rejecting the government's argument, accurately pointed out, quote, in the vast run of cases, there would be no incentive whatsoever for police to go to the trouble of getting a warrant, or, we should add, of waiting for a lawful inventory to be done during normal processing. The police should readily make this assessment on their own. Contrary to what Nix supposed, they would almost invariably be in a position, quote, to calculate whether the evidence would inevitably been discovered, because they would know the inventory procedures were in place. This concern for the effect of the inevitable discovery exception on the warrant requirement has been articulated by some state courts. To allow for inevitable discovery is to be utilized to sanctify an otherwise illegal search due to a lack of a warrant would undermine the warrant requirement entirely. A police officer with the requisite justification to obtain a warrant might be encouraged to avoid the chore of obtaining a search warrant when he can obtain the evidence faster and more easily by illegal warrantless searches and still have the evidence introduced by way of the inevitable discovery. For this reason, as well as the concern that the inevitable discovery exception would conflict with the deterrent rationale of the exclusionary rule, some states have eliminated the inevitable discovery exception when it is used to avoid the need for a warrant. Quote, were the rule otherwise, every warrantless, non-exigent seizure automatically would be legitimized by assuming the hypothetical alternative that a warrant had been obtained. Without the deterrent effect of the exclusionary rule in such circumstances, the constitutional warrant procedure for shielding Americans from unreasonable searches and seizures would be in shambles. Although the Supreme Court has not directly dealt with the impact on the inevitable discovery on warrant requirements, there is at least some indication that by the court this factor is not viewed as a problem. Murray has been used to support the proposition that the inevitable discovery can be used even where it would sanction warrantless activities. The facts of Murray indicate that there was an illegal warrantless search performed prior to the obtaining of a lawful warrant. The court allowed for the introduction of the initially illegally discovered evidence because it was subsequently discovered by lawful means. The majority refused to consider the effect that the initial illegal warrantless search would have had on other officers if nothing illegal was found. Or, to state it more graphically, why bother with a warrant if it will turn up nothing? Due to their concern for the warrant requirement, dissenting Justices Marshall, Stevens, and O'Connor argued for a broader notion of independence in order to be certain that the illegal warrantless search would have no whatever effect on the decision to seek a warrant. Quote, the court's holding lends itself to easy abuse and offers an incentive to bypass the constitutional requirement that probable cause be assessed by a neutral and detached magistrate before police invade an individual's privacy. The circuit courts generally have been less sensitive to the effect that the inevitable discovery doctrine may have on the warrant requirement. The case of United States versus Whitehorn provides a good illustration of how the inevitable discovery doctrine would substantially circumvent the warrant requirement. In this case, there was an illegal warrantless search of a residence. At the time of the illegal search, the government was working on the application for the search warrant. The court held that since there was sufficient justification to issue a warrant prior to the illegality, the evidence would have been inevitably discovered based upon the valid warrant. The court indicated even if the police has waited for the results of the illegal warrantless search, the evidence still would have been admitted. Finally, the next court rejected the assertion that the equilibrium somehow changed and required suppression when the police acted in bad faith in illegally detecting the challenged evidence. So long as it is clear that such evidence would have inevitably been discovered by lawful means, suppression is inappropriate, this court said. And it's interesting to note that the courts utilizing inevitable discovery to avoid the warrant requirement do so without considering the ramifications of their actions on the warrant requirements. C. Active pursuit requirement. The alternative investigation required of the police to qualify for the inevitable discovery exception also has an effect on the warrant requirement. The off-side case of United States versus Griffin provides a good example of this interrelationship. In this case, the police illegally entered a suspect's apartment with the purpose of securing it. Simultaneous with the discovery of various drug paraphernalia, an officer was sent to obtain a search warrant. The government sought to allow the admission of evidence discovered as a result of a warrantless search by arguing that it planned to obtain a warrant. Because the agents could have obtained a warrant, the court was asked to find the inevitable discovery exception. In refusing to find inevitable discovery in this decision, a case in which the alternative investigation was pursued at the same time the illegal was occurring, the court indicated that if it were to find inevitable discovery in this situation, it would, quote, emasculate the search warrant requirement of the Fourth Amendment. The Ninth Circuit followed this rationale in U.S. v. Allard, a case in which evidence was obtained as a result of illegally securing a suspect's room while an officer was sent to go get a warrant. The Allard court stated that, quote, any other holding would encourage law enforcement to secure or seize places and things with or without probable cause in the absence of a warrant or exigent circumstances, while they seek to do some independent evidentiary basis to justify a search warrant. It should be pointed out that in light of Murray, if initially illegally discovered evidence is later discovered by lawful means, the court allows for independent source exception. Both Griffin and Allard appear to be factually similar to the Murray case, and thus the same rationales may apply. As previously mentioned, the next decision involved active pursuit of the alternative investigation. There was a search party looking for the body when the search occurred. This active pursuit has been characterized by Brent R. Apple as, quote, an independent, inevitable discovery, because a lawful investigation would get to the same evidence as the unlawful investigation without any relation whatsoever to the legal investigation. Quote, in this context, the inevitable discovery exception stands for the common sense principle that the vagaries of the timing of discovery will not default or defeat the introduction of evidence that would have otherwise clearly been admissible under the independent source rule. This is the type of inevitable discovery that Justice Berger referred to in Nix when he declared that there is, quote, functional similarity between these two doctrines, inevitable discovery and independent source rule. Thus, the illegal discovery merely accelerated discovery which would have inevitably occurred. The active pursuit requirement of Nix has, for the most part, remained in effect. However, there appears to be at least a willingness among some of the lower circuits to depart from the mandate, and active pursuit is required by Nix. For example, the Fifth Circuit in United States versus Namer, indicated that it might be more willing to find inevitable discovery without the necessity of actively pursuing the investigation. This represents a switch in analysis from what was done to what would they have done. The Ninth Circuit in United States versus Ramirez-Scandoval asserts that it is not only necessary that an investigation be initiated prior to illegal conduct, only that a routine procedure that the police would have followed would have led to the evidence. The First Circuit found that the requirement that a separate investigation which constitutes inevitable discovery be set in motion is too rigid a test, and interpreted Nix as not requiring an active pursuit of that investigation. The circuit decided that whole probable cause existed prior to illegality, and where a warrant was applied for soon after, the inevitable discovery exception must apply. The type of inevitable discovery in which the alternate means was undertaken after an illegal discovery had been characterized by Appel as dependent inevitable discovery. He described this as after-the-fact repair of unlawful conduct. This inactive pursuit of the alternative investigation at the time of the illegality appears to have found support in Murray. In this independent source exception case, the majority refused to adopt the requirement of demonstrated verifiable fact, opting instead to rely on assurance from the police that what they intended to do was one day go get a warrant. Thus, an argument to be made that the active pursuit is no longer necessary and merely a reasonable probability for an alternative investigation is all that is required. Justice Marshall pointed out in his dissent in Murray that the active pursuit was required by the Nix decision. He further pointed out the ramifications of not requiring active pursuit, saying that the police, even when they have sufficient justification, will perform a warrantless search, a confirmatory search, before going through the hassle of getting a warrant. He disagreed with the majority's approach of relying merely on the intent of the officers to obtain a search warrant. He stated that he would prefer, quote, demonstrated historical facts capable of ready verification or impeachment, or in other words, of showing that the police were in the process or had sought a warrant prior to the initial entry. The court's approaches in Murray, along with the loosening of extra active pursuit requirement of the inevitable discovery exception and the insensitivity the court has shown towards the use of warrants, could likely signal further deterioration of the warrant requirement. Conclusion. Although some courts have taken a more restrictive approach to the inevitable discovery exception than the Supreme Court did in Nix, many jurisdictions, including most of the circuits, have expanded that exception beyond what was envisioned in Nix. The most widespread expansion, and potentially the one with the greatest ramifications, has to do with the utilization of this exception for primary as well as secondary evidence. Although the Supreme Court has not directly dealt with this issue, it indicated a lack of sensitivity to the problem as indicated by the Murray decision. The Murray case is consistent with the court's decisions in recent years, which have generally shown reluctance to apply the exclusionary rule. This reluctance can be seen in the court's recent approach to derivative evidence. In New York v. Harris, the court limited the derivative effect of a legal home arrest to the evidence that was obtained in the home. As a result of the arrest, the police acquired statements from the defendant, both in his home and later at the station house. The statements made at the station house were not subject to a fruits analysis. The court focused on the purpose of the requirement for the arrest warrant in the home, finding that the rule was designed to protect the sanctity of the home, and the court limited its derivative evidence scope to the home. Quote, the rule was not intended to grant criminal suspects like Harris protection for statements made outside the premises where the police have probable cause to arrest the suspect for committing a crime, end quote. This avoidance of exclusion of the secondary evidence could indicate a willingness to limit the thrust of the fruits doctrine. The court's general attitude towards the exclusionary rule, coupled with a decision like Harris, suggested if the court were faced with the opportunity, it might liberalize the requirements for applying inevitable discovery to avoid exclusion of secondary evidence. However, the court has not explicitly indicated that it has plans to apply the inevitable discovery exception to primary evidence. Nevertheless, in light of Murray, it is not surprising that the lower courts have chosen to utilize the inevitable discovery exception to avoid the exclusion of primary evidence. Another expansion of the inevitable discovery exception has to do with its utilization to avoid the warrant requirement for the Fourth Amendment. The demise of the warrant requirement by the Supreme Court has been going on for a number of years. This trend, coupled with the Murray decision, has encouraged most lower courts to give short shrift to the concerns of the warrant requirement and apply the inevitable discovery exception even if it effectively eliminates the incentive to obtain a warrant. This approach is usually taken without any discussion. As this article has shown, the inevitable discovery exception, which was, at least initially, an exception to the fruits doctrine, has been expanded beyond the Nix decision. Underlying this expansion has been the intent to avoid the application of the exclusionary rule. The application of the exception to avoid the exclusion of primary evidence would well signal a de facto elimination of the exclusionary rule. In addition, the utilization of inevitable discovery exception to avoid the warrant requirement of the Fourth Amendment, along with other expansions to warrantless activity, could result in the diminution of already diluted warrant requirements. Thus, these expansions of the inevitable discovery exception have very serious ramifications indeed. Given the Supreme Court's lack of sensitivity to these issues, it is likely that expansions to the inevitable discovery exception will continue unabated, unless the court needs or heeds the advice of Justice Stevens in his concurring opinion of Nix. Quote, the majority refers to the societal cost of excluding probative evidence. In my view, the more relevant cost is that imposed on society by police officers who decide to take procedural shortcuts instead of complying with the law. Ta-da! That's the end of lovely Mr. Bond. Let me find him. What's the guy's name? I have his name. Mr. Bloom, Mr. Robert M. Bloom, Mr. Bloom's article. All right, well, that's what a law journal article sounds like, especially in the criminal justice side of things. what a properly written one sounds like, unlike some other law journal articles that have been coming across people's desks and looking very much like a 4-year-old wrote them with a crayon. This one is well researched and well done. All right, well, y'all have a great night. Have a great weekend. Tip your bartenders, tip your waitresses, tip your hostesses, your cocktail waitresses, and don't drive drunk. Good night.